Do the police always have to read Miranda rights in Indiana? The answer is no. Miranda is only required when a person is in custody and they're being interrogated. The problem with Miranda, and even the courts agree, is there's not a bright line as to when somebody is in custody. There are a few ways we know we're not in custody. If a police officer just walks up to you and asks you, hey, what's going on? What's your name? Anything illegal in that car? Well, the case law is pretty clear. You're not in custody. That's a consensual encounter. And this happens all the time. Police walk up to people, what's going on? Anything I should know about? And people, I kid you not, a lot of people just spill their guts to the police. Yeah, I have some weapons I shouldn't have. Yeah, my license is suspended. Yeah, I'm not supposed to be here. There's a protective order. Yeah, I have some drugs in my pocket, but I just want to be upfront with you. People just spill their guts all the time. And they always call and they say, Mark, well, the police didn't read my Miranda rights, so I need you to get the case thrown out. They're not in custody. The officer just walked up and asked a question. Consensual encounters are allowed. Now, there's a legal gray area that's called a Terry stop. And a Terry stop does require reasonable suspicion of criminal activity. An officer is allowed to stop and briefly detain a person, and they can ask some questions. Name, what's going on? And even though the person is briefly detained, Miranda rights are not required. But Mark, you said that they're required if the person's being detained and they're being interrogated. Well, there's this little exception for Terry stop. We wouldn't want to burden these police with having to read Miranda all the time. And then the third type of stop, which is an arrest. And if there's an arrest, well, if the officer wants to ask questions, they have to read Miranda. You have the right to remain silent, et cetera, et cetera, et cetera. It's clear when someone's been arrested, they have to read Miranda. But what's not clear is when does an arrest occur? Well, if someone's in handcuffs, that's pretty much clear they've been arrested, except if it's a DUI, because there's some special rules for that. But it's very unclear. And so there are some factors to consider: whether the person was Miranda rights, whether the person was handcuffed or restrained in any way, whether the person was told they were a suspect in a crime, how vigorous the law enforcement interrogation was, whether police suggested the defendant should cooperate, implied adverse consequences for non-cooperation, or a suggestion that the defendant was not free to go about his business, and the length of time of the detention. But that list is just some suggestions that would lead a court to determine if somebody was in custody. So there's no bright line rule for when officers have to read Miranda, unless you're at a police station, you're in handcuffs, and they're asking you questions. This seems pretty clear in that case. But there's just so many shades of gray. And the courts say, well, we don't want a bright line rule because there's too many facts that can apply. So the courts are to interpret when Miranda is to be read to a person. So I'm going to tell you a shortcut to all of this. Very, very simple shortcut. If an officer walks up to you and asks you a question, simply say, am I free to leave? Now, officers may get mad. I'm just trying to talk to you. Only a guilty person would just immediately assume, I want something from you. I'm just asking you how you're doing. Listen, officer can do whatever he wants. It's America. But you don't have to cooperate and play officer games. Am I free to leave? Now, an officer may tell you, no, you're not free to leave. You have to give me your name, date of birth, your address, or your driver's license. Now, they can do that if they suspect you of committing an infraction or ordinance violation. Maybe you jaywalk, maybe you threw a cigarette butt into the street, who knows? But they can ask you for identification if they observe a infraction or ordinance violation. They are allowed to stop and detain you if they have reasonable suspicion you're involved in a crime. But if they tell you, no, you're not free to leave, that should make a light bulb go off in your head. Well, I don't want to answer any questions. I want an attorney. I plead the fifth. Am I free to leave? No, you're not free to leave. I plead the fifth. That's the easiest and shortest way to make sure you're covered. If you have a driver's license, give it to them if they ask, although there's some ambiguity whether or not you even have to do that. But in order to de-escalate things, or at least not allow things to escalate, if they ask you for some identification after they tell you you're not free to leave, you likely have to provide that. Keep that in mind. But am I free to leave? Yes, then leave. If they say you're not free to leave and then They ask you questions, I plead the fifth. There you go. If they ask for identification, it's very easy for the officer to say, I saw them commit an ordinance violation or an infraction. And that would never imply an officer would lie, but it's pretty easy for them if they wanted to lie and say they saw a person commit a fraction or ordinance violation and say they're entitled to the identification of a person. So if they say you're not free to leave, unless you give them identification, then name, date of birth, address. Am I free to leave now? No. I plead the fifth. I plead the fifth. So to reiterate again, officers do not always have to read you Miranda. They just don't. You may not agree with that. You may argue with me, but that's Indiana law. And they only have to read you Miranda if a person's in custody and being interrogated. But it's very difficult sometimes, most of the time, to figure out if somebody is in custody interrogated. So the best course of action is don't play the game. Don't play the game. Remove yourself from the game. Am I free to leave? Yes. Goodbye. I'm not free to leave. I plead the fifth. Here's my driver's license. Done. If you have any questions about criminal law in Indiana, give me a call, 317-632-3642. I love being a criminal defense attorney. It is the funnest, best, craziest, most rewarding job I've ever had. I can't imagine myself not being a criminal defense attorney for the rest of my life. And I'll talk about criminal defense all day. If you have any questions, give me a call, 317-632-3642. Most importantly, always plead the fifth.